Here we are. We're going to be doing the basic estate planning documents that everybody needs. We'll get into some that not everybody needs, but mostly we're going to deal with the basics that everybody needs. And Pamela Greenfield is with me today. Pam, go ahead and introduce yourself.
Hi, everybody, and Brian. My name is Pam Greenfield. I am an elder law and estate planning attorney. My office is in Needham, Massachusetts. And I have been practicing for about 15 years, worked for various different firms, and opened my own practice in 2018. And my office focuses on clients from, young adults who are just getting ready to go to college, all the way through to folks over the age of 100. And we do basic estate planning, we do long-term care planning, and we do some Medicaid and benefits consulting as well.
Okay, and I'm Brian Barreira, and I do estate planning, probate, and elder law. So we're going to talk now about, let's start with the healthcare planning documents.
Okay.
So the first one up, healthcare proxy. Should everybody have that?
Yes. So there are several basic documents that I always, I counsel clients that they should have regardless of their age, their health, and their wealth, if they're over the age of 18. The first sort of batch of which are healthcare documents. So the first most basic healthcare document that everybody should have is a healthcare proxy. So in the state of Massachusetts, there's a statute that governs healthcare proxies, and there's actually a statewide form that's available online and often at your physician's office. That form is pretty good and has some good benefits. It allows you to name a primary person to be your medical decision maker and also an alternate agent. But there are limitations with that form. So I always tell clients it's better than nothing, but it's much better to work with an attorney to prepare a healthcare proxy, because there's a lot more that we can put into the form than just who are these appointed agents. Who these appointed agents are individuals that you trust to make medical decisions for you in the event that you couldn't make one for yourself. So this could be the scenario where somebody is incapacitated because of a long illness or because of a major medical event that occurs. And this healthcare proxy goes into effect when it's activated by a physician. It needs to be activated by a doctor to sort of spring into operation. And it can come and go. So if the person that is incapacitated at the moment is has a medical event and they're in the hospital and they can't make their own healthcare decisions, the doctor can activate this document and have the person who's named in the document to serve and make important medical decisions. When that person regains consciousness or is able to make their own decisions again, they would resume their ability to do that. So the healthcare proxy doesn't take away your decision-making authority. It just allows you to name somebody in the event that you can't make it yourself. And there are, all kinds of considerations to make in naming a healthcare agent. So you definitely want it to be somebody who you trust, who's readily available and accessible to be there at the ready if healthcare decisions need to be made, and somebody that you've shared your philosophy with on the things that you would want and the things that you would not want. Anything you want to add?
Well, the basic document only needs to name people and to be witnessed by two people who are not named.
Correct.
But it's not enough to just do the healthcare proxy. Got to be able to find it when you need it. I just had a client in this morning. I said, "Where is your healthcare proxy?" She told me in her safe deposit box.
Right.
Well, what good is that at 1 o'clock in the afternoon on a Saturday? If you really need it, and I tell older people, especially married couples, make copies, put them in your car.
Yeah.
If somebody's being rushed to the hospital, you know where they are, It's just a copy. You can have the original somewhere else. So
Right.
that's one basic document that everybody needs to do.
Right. And to
So,
piggyback off of that, we like to scan in our documents and have them electronically. And I often tell my clients after the healthcare proxy is activated to send a copy to their physician. So the physician has it in their chart, and to send an electronic copy to the people that are named in the document so that they have it, at their fingertips if mom or dad ever goes to the hospital.
and it might be good to just renew that email once a year,
Yes.
just to remind people about it.
It bears
So,
mentioning, though, that if you go to the pains of working with a lawyer to do a healthcare proxy that's a little bit more souped up than that state form, if you do go to the hospital and you're handed an admissions packet, you wouldn't want to sign their healthcare proxy form at the hospital because it would override the one that the lawyer did. So that's another thing I like to tell my clients to be aware of.
okay, so the healthcare proxy only gives access to medical information upon your incapacity. So the other document that's a good one to have, this may not be a must, but for some people it might be, is a HIPAA authorization.
Yes.
Right,
So
Pam?
we do HIPAA authorizations in conjunction with our healthcare proxies. So we do a suite of 3 documents, and I'll get to the third in a second. But Brian, you're right. The healthcare proxy springs into effect when it's activated by a doctor. But oftentimes my clients need access to medical records or access to physicians, their children do. Or their spouse does when they're caring for a loved one that has, a diagnosis that maybe doesn't render them incapacitated to make their own decisions, but it warrants another set of ears in the room, or a follow-up phone call from one of the children. So the HIPAA release form is a general blanket form where I have my clients list all of the individuals that they are comfortable having access to their medical records and the ability to speak with the physicians. And the nice thing about that form is that it's a general form. So most of us have signed forms at the actual doctor's office, authorizing certain people or certain other specialists. But this is a general form that can sort of go anywhere.
I often ask families, do they have anybody in the family who's a nurse or a doctor? Even if it's not really the closest relative that they would put in a decision-making capacity, because that might be the interpreter for the family.
Right.
So those are the basics. Now I think you're probably going to go on to what might not be needed, but is advisable. Go on. I'm probably going to talk about a living will.
Yes. So different estate planning lawyers handle the concept of a living will differently, right, Brian? There is no living will statute in Massachusetts. So the way I describe this document is really, it's a compassion document for your kids more than anything else. So if you've ever been a child or a loved one and you've sat in a room and had to make a very difficult decision for a parent or a spouse, or somebody else in your family, I've sat across from clients who have said that is one of the most difficult moments of my life. So the living will is really an opportunity more than anything for our clients to state their wishes for end of life care treatment, so that it's sort of out there in the universe, for a few reasons. One is it really offers some guidance to the people that are going to be in that hot seat, that are going to be giving your instructions and your wishes. That person under the healthcare proxy statute has that authority. But if they're sort of going in blind and they don't have anything to rely on to know what your wishes are, that's a very difficult emotional position to be in. So the living will offers an opportunity to sort of mitigate that a little bit. It's also very helpful in the event of a family dispute. So even if you have a named healthcare agent, there could be another family member who disagrees with the decision of the healthcare agent, and then it would be extremely valuable to have some evidence of what the incapacitated person wanted. So the living will is a very useful document, although it's not technically a legally binding document. And we offer it to clients. I don't know how you do this, Brian. We offer it to clients as an option. And if they want to do it, great. If they don't, then we don't do it. I've worked for firms in the past and used other legal documents where it's in the actual healthcare proxy, but I've gotten away from that. What do you do with that, Brian?
I have gotten away from doing this because in my experience, people just sign whatever I put in front of them and they don't change anything. I used to put it right into the healthcare proxy. So I've taken it out. I just don't want to be in the spot where people are signing something and it's not really what they wish.
Right.
I don't think they want to put a lot of thought into it. So, and plus, there are statistics out there that these things are not even looked at.
Yeah.
And so by doctors and hospitals. So, it's more of I think it's better for the family to be battle ready verbally on what their wishes are. And then if somebody is truly not well, this is not an estate planning document, so this is outside of what we're talking about. Is there's something called the most that you do with a physician, and that's really in many ways a DNR.
Right, and that's clients often ask me, what's the difference between a living will and a MULST? So the MULST stands for medical order for life-sustaining treatment, and as Brian, as you said, one is a medical order, the other is a sort of a quasi-legal document. So they operate in different spheres. The other thing is that the living will can really say anything you want it to say, whereas the MULST form is a hot pink form that is a state-run form that it's a checkoff. So you say, yes, I would want this. No, I would not want this. It's very standardized. So there's a little bit of a difference and a nuance there.
Okay, so we're halfway through our time already, and we haven't gotten to the financial types of documents that everybody should do. So let's skip over, if you own a home, and just quickly go over homestead, because that's something that's an easy one for homeowners to do.
Yes.
And you do it once and you don't have to redo it.
So a homestead, as you are alluding to, Brian, it's a simple form you can file. It costs $36 or $35 at the Registry of Deeds to file it, and it protects your home from non-government creditors. So if you're under the age of 62, I believe it's $250 a person, right?
There's $500 for any homestead now.
Oh, it is?
Yeah.
Regardless of age.
So but you can stack them. If you're over 62, you do a regular, and then you could do an elderly, and effectively get $1 million of coverage. And a lot of those things are gone over. Basic homesteads have gone over when you refinance, when you buy a house, and then closing attorneys.
Right. Often I do them too. When I put homes into trusts of any kind, I do a different kind of a homestead for trusts.
Right.
So
go ahead.
Right. I was going to say they offer protection from non-government creditors. So that's important to note, is that we're talking about, if you ever got into a car accident and got sued for more than what your liability insurance would cover, or if you had a business that went south, the homestead can be very effective. Where it's not effective is protecting your home from a Medicaid lien if you ever went into a nursing home, or any kind of other government creditor like the Department of Revenue or the IRS.
Or the bank or the mortgage. It doesn't protect you from your mortgage either.
Right.
So, all right. So let's get over to the estate planning documents that deal with your assets when you die. A will and a trust.
Skip over powers of attorney?
Yeah, let's save that for the end.
Okay.
Go ahead.
So, I often tell clients, they call me and they say, I need a will. I need a basic will. And the will is often the least important document that we draft for people, because the whole idea in 95% of the times is to not use the will. So the will, everybody knows what a will does. It says where your assets are going when you pass away. What most people are confused about is having a will doesn't avoid going through the probate process. Having a will just clarifies what your wishes are when you pass away with respect to your, what we call probate assets, which are assets in your name alone with no beneficiaries and no joint owners. So our clients that own joint property with a spouse or a sibling or a friend or a child, or our clients that have assets that have beneficiaries named, like a life insurance policy or an IRA, those assets pass outside of the probate process, and it's irrelevant what the will says because those assets have contractually named beneficiaries on it that passes in it, pursuant to different regulations and statutes. Also,
right. So the will provides a path if the asset doesn't already have a path on it.
correct. That's a great way to say it.
Okay. Right.
And in order to, and it doesn't just work like that. It doesn't work, as we know, it doesn't work. You have a will, it says where your stuff is going, and then automatically you can have access to move the stuff from point A to point B. As you said, Brian, the will provides this path, but in order for that path to be validated, it needs to go through the probate process, which in Massachusetts can be a pain in the neck. It takes some time, it can be costly. It's
much
a
lower
public
pain.
event. What'd you say?
It's a much lower pain.
It is.
Not a pain in the neck.
It's a lower pain. It's actually a bigger pain in other jurisdictions though, because there are always these myths, like if you go through probate, you have to pay the state a tax. That's not true. But the probate process itself takes a while, and there are easier ways to pass on property.
And our court system is in a mess right now, and they're not even dealing with the paper that's submitted to them for months sometimes.
Right. Or they're sending it back. There's a big delay. So it's better in 95% of the times, and there are times when using a will is the best way to go, but there are usually better ways to pass on property. I apologize, my dog is barking. Using a trust is one way, and Brian, you and I are always deeding properties into real estate trusts to help our clients for various different goals. Trusts can come in all different shapes and sizes. You can have irrevocable trusts, revocable trusts, special needs trusts, tax trusts, all different kinds of trusts. But often those are the better ways to pass on property because you avoid this probate process. The only other thing I always mention, because I work a lot with young families and I have young kids, is that the will is the place where, if you have minor children, you name a guardian and conservator for your minor children. So that's often for my clients who have minor kids, that's often the biggest thing that's weighing on them when they come in to see me is, who do I appoint in that role, and how does that logistically go down?
Okay, so we've dealt with what happens for healthcare, what happens when you're gone. And now, to me, power of attorney is the most important document I do for most people.
Oh, so that's why you save the best for
I
last.
save the best for last because there are different angles you can take on this. There's a regular one where it's effective today, or there's one that only springs into existence, or the powers only spring into existence upon your incapacity, and the person you appoint has to jump through hoops to be able to prove that you're incapacitated. Go on, let's talk about some of the provisions in powers of attorney.
So powers of attorney, as Brian said, are ways to name somebody to stand in your shoes and make financial decisions for you if you can't do it yourself. So think same idea as a healthcare proxy, but a power of attorney deals with finances, where a healthcare proxy deals with medical decision making. The healthcare proxy we talked about needs to be sprung into effect by doctor's order. The power of attorney under the statute can be drafted one of two ways. It can go into effect when it's signed, and then it's sort of, there's no triggering language. Like if I make Brian my power of attorney right now, there's nothing stopping him from going to my bank and withdrawing the funds. Now, there might be other provisions in the document that speak to that. There's certainly a fiduciary obligation to use the document in my best interest. So, removing all the funds from my account and putting it into his would probably not be in my interest. So that would breach his fiduciary duty. But there's no mechanism to prevent him from accessing my finances or making financial decisions or moving money around or anything like that. So some clients, and I actually admittedly don't do this very often. I don't know if you do, Brian. They do something called a springing power of attorney as compared to a present power of attorney, which is what we just discussed. Springing power of attorney operates like the healthcare proxy. It needs to be signed into effect by some mechanism. So we can put in the document what that mechanism is, whether it's one physician or two physicians. Do you do a lot of those, Brian?
I don't, I'm doing more and more of them. And a lot of times I do it springing on the successors in the document.
Yeah.
So if you're married, you give your spouse power immediately. But if your children are going to be able to step in, you make sure that they have to jump through hoops so that they don't do something that you wouldn't like.
Right. And the powers of attorney can be as broad and as narrow as we want them to be. So, I generally throw the majority of the items in the kitchen sink into my power of attorney. And then if clients have concerns, I peel it back. So I usually am more inclusive and then take provisions out that don't feel right. The questionable, there are certain provisions that every power of attorney has, like banking authority, buying and selling real estate, investing, paying bills, filing taxes, filing lawsuits, dealing with a pension company, dealing with a health insurance company, anything you could think of in your day-to-day life that you would do, what we call attorney in fact would be able to do. Then there are some other provisions, more questionable provisions, like, do you want to give your attorney in fact the right to change your estate plan, or to make lifetime gifts, or to create a trust on your behalf? So those kinds of things, are sort of an outcrop of the work we do. And if these provisions are not specifically outlined in the document, we often have to go to court and have a judge give us the authority to do these things as attorneys. So it feels compelling to put these provisions into our documents, but we have to do that. We have to do that cautiously, because we need to make sure that it's appropriate for each of our clients.
Yeah. I try to make sure that the gift giving provision is not broad, but mirrors the will.
Yeah.
So, I've seen gift giving provisions that put limitations that you can't give more than 5% of my assets away, or and you can't give it to the gift giver.
Right.
But sometimes it makes sense if it's your spouse and we're doing mass health planning to be able to move assets back and forth between spouses. You want to make it broad, but it's got to mirror. It cannot be generic, because now you're giving too much authority to somebody to change your plan.
Yeah, I agree. You have to use it sparingly.
And one other thing about it is it only needs to be notarized, but if you want to use it in some states, they require 2 witnesses, like Florida.
Yeah.
So I try to find out if people have real estate in Florida, and if they do, then I make sure we execute it similar to a will.
I think that's a requirement in New Hampshire too, right? I think it's 1 witness in New Hampshire. Some law firms, and it's interesting that you mentioned this, because I used to have my power of attorney witnessed, And then I got away from it. And now I was thinking about doing it again, because just because they don't own Florida real estate right now doesn't mean they won't in the future. So maybe if you're executing other documents, maybe it makes sense to just witness the POA.
And one other thing is the alternative to a springing power of attorney is for someone to hold the actual document in escrow. I don't
Yeah.
like doing this. I don't want this responsibility. I've done it for a couple of clients. The problem I have with the springing power is it essentially says to all financial institutions, I didn't really trust this person to step in.
Yeah.
And so it's to not have that taint and to allow a quicker use of the document if it's needed, someone can hold it in escrow and they can release it.
Right. The thing that always troubles me is that the activation of a healthcare proxy is something that naturally happens in a healthcare setting. This is, using a power of attorney, you're stepping outside of the financial world and you're stepping into the medical world and you're asking for a determination of a person that's not, in that setting at that moment. And it's just out of the normal course of the way things operate. So it can get cumbersome.
And the doctor might not want to sign something like that
Right.
and have the responsibility.
Right.
So there can be extra delays when you make it springing. But
It bears mentioning, I know we basically out of time, but these documents, the power of attorney, the healthcare documents, they're what we call the decision-making documents in my office. And if you think probate is bad, going through the probate process is bad, it's really the guardianship and conservatorship process that these documents are avoiding. So if we're able to execute good, solid healthcare proxies, powers of attorney with primary agents and alternate agents, and the documents are well prepared, avoiding the need to go to court to become the conservator or guardian for a loved one is absolutely critical. So that's what we're trying to avoid.
right. And I once had a case where there was a $14,000 bank account that the second wife couldn't get to, and there was no power of attorney. We had to do a conservatorship. So she was paying me. The court appointed a lawyer to represent her husband and a guardian ad litem, a second lawyer. And then the children from the prior marriage hired their own lawyer. We had 4 lawyers arguing over 14 grand. And so that's why you do a power of attorney. And that's why that's the most important document to
Yes.
keep things simple. All right. Pam, thank you. Anything else to add on anything
I
here?
don't think so, Brian.
I think we pretty much
How
covered-
often do you have your clients update these documents?
Well, you don't really need to update a will or a trust, right?
Right.
Healthcare proxy, the law has never changed. I've never seen that document challenged for age. It's the power of attorney that used to get challenged under the prior law. But I think it's probably a good idea about every 5 or 6 years to make sure you re-sign a power of attorney.
Yeah, I agree. And to make sure that, you're sort of doing a gut check. Are these still the right people to make decisions for me? Sorry, I live in a zoo. There's all kinds of animals in my background here.
So the other documents that we didn't get to because we wasn't part of this is there are kinds of trusts that deal with what if you need nursing home care, you want to protect your assets. There are trusts that deal with estate taxes where spouses can minimize the estate tax. There are trusts that protect the the benefits for people who have special needs. So we're just doing the basics. Maybe sometime in the future, we'll go a little deeper.
I'd be happy to come back and do that with you,
All
Brian.
right. Thanks again, Pam. Take care.
All right. It was nice to see you. Take care, everybody.
Take care. Bye.
Bye.